Welcome back to Legalese 123, where we are covering cases across America. Hello and welcome back to Legalese. I'm your host, Misty K. We've got some breaking news coming in for the Aaron Spencer case. As I might have stated to you earlier on my Brendan Banfield posts, Aaron Spencer, well, we thought that they were going to have a hearing this Friday in reference to having a defense witness come in and testify to what she was going to state before the trial happened next week. But whammo shablamo, we got hit with a defense motion to recuse Judge Barbara Elmore. And if you heard me say this before, I asked, why wasn't this done earlier? Because it was alleged, or we thought, we didn't have the materials that stated, we thought that when Michael Fosler was convicted, or sorry, not convicted, when Michael Fosler was charged with the 43 counts of sexual misconduct in reference to a minor, which happens to be Aaron Spencer's daughter, we thought that the judge in that case was Barbara Elmore. Well, it turns out it was the other judge who heard the bond charges. And we'll go over that here in just a second. So it's quite ridiculous. Let me give you a quick recap of roads so far. Aaron Spencer is being charged with unaliving 67-year-old Michael Fosler. It's very important that I state how old he is. Fosler was accused 43 counts of sexual misconduct with Aaron Spencer's 13-year-old daughter. I kid you not. 13-year-old. Is 13-year-old enough to consent to a relationship with a 67-year-old man? That's what the state is alleging. What happened? In June or July, my dates are messed up, Fosler found out that this was happening. Fosler then was arrested. He had the 43 charges put onto him. He was supposed to have no contact with Spencer's daughter. But somehow or another, between that time and October, he had contacted her on 3 separate occasions. And on this night in October, he lured her out of the house at midnight. Aaron Spencer awoke to his dog barking, went to her room, found she wasn't there. He went to go look for her. His wife had called 911. He went out searching for his daughter. He found Fosler's truck, and his daughter was inside. At the time, he didn't know, but we know now that Fosler was bringing her back after SAing her that night, bringing her back to her residence. Spencer chased Fosler, bumped him with his car. He went into a ditch. Spencer requested that he get out of the car. Fosler got out of the car, reached for something. Spencer unloaded his weapon on him. Fosler is deceased. Now Spencer is being charged with Fosler's unaliving. That is the case in what we're happening right now. So let's go to the docket, because today, boop, boop, ba-doo, they entered into some new motions here on the docket. So as you can see down here below, at 8:04 p.m. last night, I was watching the Hoosier game. Defendants brief in support of motion for judicial recusal and the motion for judicial recusal. So let's get into it. I thought it would be nice for us to look at this. All right, so let's go and stop this, and let's bring this up. Okay, I don't know why this is doing this, but this is the route we're going to go. All right. Let's make this bigger. All right. The defendant Aaron Spencer respectfully moves for recusal of the presiding judge pursuant to Rule 2.11a of the Arkansas Code of Judicial Conduct. The cumulative record of these proceedings results in reasonably question about the court's impartiality. This case arises from the killings of Michael Fosler, who had lured Spencer's minor daughter from her home while facing dozens of felony charges arising from sexual offenses against her. Fosler was free on bond at the time, bond issued through this court, and was killed during Spencer's efforts to recover his child. From its inception, the case has drawn intense public scrutiny regarding the court's decision to release Fosler on bond. The propriety of the charging Spencer for his actions taken in defense of himself and his child, and the integrity of local law enforcement given its failure to preserve critical evidence. Remember, the dash cam video evidence is missing. Spencer, his counsel, his family, and others have publicly criticized those actions. In early proceedings, the court entered into an expansive gag order, sealed the case, and limited public access without a hearing or factual findings. They did that. So immediately, as soon as this became something of an issue, the court put a gag order on it immediately. And so that Spencer and his family were unable to talk about the case. And so they brought it up to the Arkansas Supreme Court, and they eventually overturned that. And so now we can talk about it. They vacated that order, expressly cautioning against courtroom closures and secrecy imposed without adherence to constitutional requirements. Several justices warned of a troubling pattern of attempts to shield this case from public view. This is, in their opinion, warranted reassignment even then. Following the Supreme Court's intervention, the court's subsequent rulings have reinforced, not alleviated, concerns about impartiality and secrecy. The court imposed compressed and impractical scheduling directives while discovery was still being produced. Both the defense and the prosecution asked for more time. She said no. Required duplicative filings shortly before major deadlines, and denied defense requests for additional time despite late disclosures by the state. During the pretrial hearing, this was held on the 17th and 18th of December, the court curtailed discussions of Fosler's abuse and its relevance to the defense, permitted the state to proceed with expert testimony despite belated discovery related to that expert, and mischaracterized defense advocacy as improper. The hearing culminated in a public accusation of misconduct against a member of the defense team, made without evidence and in open court, resulting in attorney's removal and exclusion. I do remember they said that somebody was taken out because she didn't want anybody to have their phones out, and I think that they were looking up something for a case, and she kicked them out. Also, in this hearing, again, it's alleged, we weren't there, we only know what has been reported out, is that again, the defense wanted to have this Carrie Landau come in and do an expert testimony. And we don't know exactly what transpired, but when the defense said, hey, we want this expert to come in, the judge quickly made a order on there saying that they had mischaracterized evidence and that she didn't do these things. And then that is why she had a hearing for her this Friday. So there's a lot of sketchy things going on. The hearing culminated in a public accusation of misconduct against the member of the defense team made without evidence. Okay, so the attorney violated no rule and did nothing improper. The episode publicly branded the defense as untrustworthy and reinforced. Uh-oh, someone's meowing out here. It's my cat. The episode publicly branded the defense as untrustworthy and reinforced the perception of hostility towards defense counsel. Most recently, the court entered into a sua sponte order limiting public and media access to the trial, capping attendance and providing no alternative means of observation, again without evidence, findings, and consideration of alternatives. She certainly did. It's a small courtroom. And she knows, she said there's going to be no live media coverage. I asked about that. It reminds me of the Richard Allen case in Indiana. No media, not very many people can come. So the order functions as a courtroom closure and mirrors the secrecy concerns already condemned by Arkansas Supreme Court. Viewed cumulatively, these actions created a reasonable perception that the court has responded defensively to public criticism, appellate review, rather than correcting course. The appearance of partiality is further magnified by the nature of the trial itself. A substantial portion of defense will focus on investigative failures by local law enforcement, including the failure to secure and preserve evidence. The court will be required to rule repeatedly on objections, scope of cross examination, impeachment of law enforcement witnesses, and expert testimony addressing these failures. The court's long-standing professional relationships with local law enforcement create an appearance problem in this context. Regardless of subjective intent under the unique circumstances in this case, a reasonable observer would question whether the judge with institutional ties to the very agencies whose conducts will be scrutinized can impartially adjudicate these disputes. That concern is further magnified by Spencer's current status as a candidate for public office. Spencer is now a political actor and, by extension, a political adversary of a public official expected to be a witness in this case, with whom the court has worked professionally for many years. Spencer decided to run for office in significant part as a result of his experiences with these officials and has campaigned on those issues. His criticisms constitute protected political speech, but they nevertheless place the court in a position where its rulings may reasonably be perceived as entangled with institutional loyalty or political context. Recusal is required where a judge's impartiality might reasonably be questioned. Here, where the court will preside over disputes directly implicating law enforcement conduct, where public confidence has already been strained by prior rulings, and where the cumulative record reflects a pattern that reasonably suggests partiality. Reassignment is necessary to preserve both the reality and appearance of a fair trial. Spencer respectfully requests that the court recuse from further participation in this matter and that the court be reassigned to another judge. Spencer does not object to an entry of an order of recusal without a hearing. In the alternative, he requests a hearing on this motion. Wherefore, the defendant, Aaron Spencer, asks the court to recuse from this case and seeks expedited appointment of a specially appointed judge and for all other relief to which he is entitled to. XOXO, the defense attorneys. All right. So, one other thing that we have to go over is there are some filings that the court put into place, and I don't know what these are. So, we're going to kind of look at them together and see. So, here we go. Let's see what this is. Oh, I'm not sharing with you. Okay. So, defendant Aaron's. Oh, hello. Why is this not? Oh, here we go. Added to the stage. Let's make it a little bit bigger. So Aaron Spencer submits the following exhibits with his motion to judicial recusal. Emails to the district courts, blah, 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 blah. So here is to Mr. Goodrich. I believe someone from my office has called and perhaps even made this request in writing before, but I'm unclear as a result. Could you please provide me with records of Michael Fosler? And he says, we don't have any records for Michael Fosler. And she says, to be sure, you don't have anyone named Michael Fosler just in case the date of birth is incorrect? Correct. I have no one named Michael Fosler. Where are his records? Because they're entitled to them. Good afternoon. Michael Kaiser asked me to request a full file regarding the state of Arkansas versus Michael Fosler. Thanks so much. This is dated December 31st, 2024. So this was just a year ago, because last year was 25. Okay, good morning. Please let me know if you received an email requesting the full file. January 3rd, 2025. I've attached the documents you were requesting on this case. So that was earlier this year. Thank you. Please send all documents in this case. Only 2 documents are sealed, so I would expect only the orders related to those 2 documents. Also, please send all documents reflecting the bond decision. Please note new email. Hello. Please consider this a follow-up from the original FOIA request. So this was sent, it looks like June 3rd, 2025. Okay, so they got something that looks like a waiver. Uh-oh. Internet went out. Okay. Shh. All right, so a waiver. A waiver. I'm not sure what this is. Okay. So here we go. Here are all of the accounts against him. Chuck Graham, prosecuting attorney within the 23rd Judicial District of blah, 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 2 counts of internet stalking. Meeting actually occurs with a child 15 years or younger. Did lawfully use computer online services. Okay, we already went over all of the counts that he had. He had 43 counts against him. Was there not a bond hearing? This is December 12th, 2024. I've attached the first appearance form and some other material. Judge Teresa Smith, the Lone Oak judge, presided over his first appearance at the jail and set bond. Remember, there's only 2 attorneys or 2 judges, so Smith and Elmore. So here is the pretrial order, and it's very hard to read. So I can't read some of this. I can't read like what the date was. And the defendant is in custody. It talks about his $50,000 bond. Defendant is hiring a private counsel. The defendant shall have no contact, either directly or indirectly, in person, by telephone, social media, or any means with, and it just says any something. I could see if I could try to make it larger. Any minor. That's what it says. Any minor. And it was dated the July 12th, 2024. Okay. It talks about what they got. It says you don't need permission. These are public documents. This is the first time we're seeing them. That's what I thought. And since it involved kids, she also said that items we were requesting were not CC'd for the public. So I don't know if she means by the judge or what. Please see attached. Thank you. So they were asking for, this was what day? October 28th. So this was just October. They're asking for certified copies of the bond and all of the other information. I sent 3 days ago. Please confirm receipt. Hello, I'm going through the request and I will get them done at some point within the month. Thank you for your patience. Also, will you be picking up the document in person? This is from the criminal court to her in a month. It's October, so now we're in November. Is this what they're saying? Hello, I have a certified copy of the waiver, arraignment, and plea not guilty of. Will somebody come and pick it up? This is November 4th of 2025. Okay, apologies for the delay. We all have 3 documents ready. This is November 7th of 2025. They did not receive the bond order. This is November 12th, 2025. We only received a bond sheet. We need a certified bond order representing the judge's ruling on the term of Fosler's bond and signed by the judge. The cost is $5 per certified copy for the 3 copies. The check should be made for $15. I will send somebody to pick them up. Please tell me how much we need to make the check for. Apologies for the delay. We have all 3 documents ready. Okay, this is on November 12th. Madam Clerk, if you do not have or cannot find the order filed in your office that reflects the bond conditions set for Michael, could you state specifically the reason and identifying the missing item? The clerk's office does not have any bond order for Michael Fosler, or the clerk's office cannot locate any bond order for Michael Fosler, or whatever the precise issue is that you're rendering to you unable to produce. We appreciate your efforts to produce public records and explain why it is unavailable. I believe you're looking for a pretrial order. It is from the original BW case. It has a bond amount and a judge's signature. I have printed it and certified. I don't know where it's filed per the ASC. It should be made part of the criminal file. We will send somebody to get it as soon as possible. Now we're on November 13th. Good afternoon. On behalf of Barrett Smith, we could please order certified copies of the following documents: the gag order, our response, the court order. The judge approved you getting certified copies or the requested documents certified $5 each. You're welcome to pick them up and pay. This is on December 13th, 2024. So now we're kind of going backwards. I don't know if they're trying to lay a history of that they still needed more time. Okay, it shows the criminal information was amended on the 13th. It's not available to the public. I called the courthouse and they also reiterated it's not available to the public. This is January 15th of 2026. So this was 5 days ago, where they still don't have things and they're supposed to go to trial next week. Judge Amor, I wanted to bring to your attention that I filed the this is December 15th, PHV motion moments ago requesting to permit one of the firm's lawyers to participate in the Spencer case. She is a licensed in Minnesota. We talked about that. Yep. I will not decide on the motion for the 17th, so she's on your list. I will not be emailing or responding to emails from this day forth. Okay. Okay, so that was one. Let's see what the other one looks like. Okay, so it's the same thing that we just went over. Okay, well, actually, let's read this one because it looks like it might be just a smidge different. Okay, let's bring this one up. No, I want to remove this one. Okay. Let's see, is this the one I'm looking at? It looks like it. Okay. The defendant asks Your Honor to recuse herself. Okay, we talked about that. So here we go. Seeking judge document promotes Okay, Aaron Spencer intends to show that at trial he killed 67-year-old Michael Fosler while defending his then 14-year-old daughter, whom Fosler had lured from home in the middle of the night. At the time, Fosler faced 43 counts of M. And yet Fosler was free on bail the night of October 8th, 2024, released by this circuit court. Spencer discovered his daughter was missing. He contacted law enforcement, began searching for him himself. He soon encountered Fosler's truck. Spencer feared not only he would renew the abuse, which had already happened, and Fosler would eliminate the sole witness standing between him and his life sentence. There is apparent and actual bias against Spencer and his legal team. Oh, I'm just not even sharing this. Sorry. Okay. At Spencer's arraignment, the court was closed to the court closed the courtroom to the public in violation of Spencer's constitutional rights to a public trial and corresponding right of the public to attend the trial. 2 days later, the state sought an overbroad gag order. We do know about that. Arkansas State Supreme Court intervened. Resistance to the disclosure of public records. During the same period, defense counsel attempted to verify information reported about Michael Fosler's bond, a proceeding that, from all available records, traces back to the circuit court. The district court confirmed it had no record of any appearance by Fosler. This is where all those exhibits that I showed you. The clerk produced the information and an online docket sheet, but no bond order. The court reported confirmed that no verbatim record of Fosler's bond proceeding was made and no waiver of such record appears in the court's file. Arkansas law mandates that a complete record be made in all circuit court proceedings unless waived by all parties. Yet, despite repeated requests for what should have been public, a complete record of the court's business, no such record was located. Both before and after the gag order, Spencer and his representatives have been publicly critical of the Lonoke County officials, including the prosecuting attorney, law enforcement, and the circuit court. The criticism focuses on part that the circuit court's handling of Fosler's release was an unreasonably low bond with no meaningful restrictions or supervision, and the prosecutor's decisions to charge Spencer under those circumstances. The issue of who set Fosler's bond was raised in Spencer's opposition to the gag order motion, discussed in multiple briefs, and discussed before the appellate court. Throughout that entire period, neither the state nor the court ever suggested that anyone other than the court had set Fosler's bond. That silence is significant. On May 29, 2025, the Arkansas Supreme Court granted Spencer's petition. You know about that. Whether the court personally signed the order or directed another judge sitting in the circuit court to do so, the bond was issued through this court, and this court subsequently presided over Fosler's criminal case. The case charged 43 offenses, including additional felony counts of a different nature not known at the time of the arrest. Despite new and serious allegations, the court never revisited or modified the bond conditions. Instead, this court allowed Fosler to waive arraignment, set a pretrial and trial dates, sealed the affidavits supporting the arrest warrants, withheld the felony information from public access, entered final judgment after Fosler's death, and sealed his death certificate. Oh, they certainly did. A year later, when the defense counsel sought of a certified copy of the order granting bond, the same resistance reappeared. When counsel staff called to request the documents, the clerk advised that the court had to give permission before releasing public records, even though it did not contain any confidential information and was not under seal. Oh, these shenanigans remind me of the Karen Reed case. After weeks with no response, written requests followed. The clerk eventually claimed her office had no bond order. After several more emails and with specific requests for an explanation, the clerk produced a bail bondsman form. When defense counsel asked for a written statement acknowledging the absence of the court order for Fosler's bond, 2 weeks after the first request, the clerk finally produced a pretrial order ordering the bond. The bond order provided by the clerk, however, does not match the document sent to the state several months prior. It is altered to contain a case number, although the case number does not return to any open case on case search and is not the number for Fosler's criminal case. You can't make this stuff up. The bond order thus remains inaccessible to the public. The search warrants and affidavit warrants. The only constant in these irregularities is the assigned court and court control over the record. Oh my gosh. The pattern of withholding and gatekeeping of public records extends beyond. I'm only on page 9. There are 26 single instances in December 2024 and January 2025. After 3 weeks of follow-up phone calls, emails, the circuit court clerk, acting under the court supervision, produced only 2 documents in response to the request for the entire case file, then ignored follow-up inquiries. On multiple occasions, the clerk told defense counsel, staff, and others that she needed the court's permission to provide documents, including in situations where no sealing order was cause for sealing existed. According to the clerk's comments to the counsel staff, the court also appears to determine which filings are visible on the public case search. For example, the charging information in Fosler's case remains unavailable online despite no reference to any specific minor. The pattern continues even this week. It suggests concealment and control over what the public knows, proceedings handled in this court, cumulative results. The court has repeatedly exercised its administrative authority in ways that hinder defense preparation. Without prior discussion or necessity, this court entered a scheduling order that imposed impractical deadlines. We already know that. On December 2025, pretrial hearing demonstrated inconsistent with judicial neutrality. Through the rulings in court management, the court fostered hostility towards the defense. Before the hearing, the court sua sponte entered an order removing Lonoke County Sheriff's Office from the courtroom security and declaring the court would be made alternative security arrangements. What followed was a show of force unprecedented for a pretrial proceeding, particularly with the defendant not in custody and without any prior demonstration of a propensity to escape or engagement in courtroom displays of violence. Officers from at least 5 law enforcement agencies saturated the courthouse inside and out. At least 4, sometimes 6, Arkansas State Police officers remained stationed around the courtroom at all times, one positioned directly beside Spencer. Additional officers occupied the hallways, stairways, elevators, and entrances. Police vehicles ringed the building and established another perimeter some distance away. Drones patrolled the overhead. Officers escorted Spencer to and from the courtroom. Police attendees were not permitted to bring electronic devices into the courthouse, and all bags were searched prior to entry. The parking lots around the courthouse were closed and empty, other than the police units guarding them. From the outside, the courthouse appeared closed to the public. This excessive display discouraged the public from attending and conveyed the message that the Spencer posed a unique threat. Ooh. Is that a poison of the jury pool? Once proceedings began, the court's demeanor toward the defense counsel was openly dismissive. The court expressed irritation about late stuff, even though the defense counsel had not missed deadlines, and launched into a rebuke. No more trying to get around doing a reply brief by doing a Second Amendment, Third Amendment, because the law hasn't changed. Ooh, boy. Let me stop you right there. I enjoy the theatrics as much as anyone else. Oh, she sounds like Judge Beverly Cannoni. The court repeatedly interrupted counsel when discussing evidence of Fosler's abuse. Well, Your Honor, the state hasn't presented any evidence yet. Expert testimony is admissible when it assists the jury to understand the evidence. Wait a minute. Having been charged with it, wait a minute. We're not having a trial on Michael Fosler in this case. Do you understand me? Michael Fosler had never had a trial, okay? So we're not going there. And we're not going to go there today in this. So the jury's not going to know that Michael Fosler abused this minor, was arrested, charged, released on bond, and then the court then came back and picked her up during the night. I expect some of that to be done, but I also expect that the jury is smart enough to figure out things without your expert telling them what to do or what to think about the situation. I think you're only trying to confuse them and bring in things that they do not need to hear anymore. Well, if the state's position is that the minor was not abused, nor not groomed, was not manipulated, I don't know. Wait a minute. That I don't know what the state's position is on all of that. I know what you say. I have read it, reread it in your motions, but I'm telling you today that my jurors will be smart enough with the evidence presented, and not this expert witness that you intend to call. I think this is Carrie Landau. And that the ruling on the court, if you want to file something, I've already told you to do that, but that's on this one. By cutting off this line of argument and refusing even to allow contextual discussion of Fosler's conduct, the court effectively shielded Fosler's actions. This precipitating events of this entire case from the fact findings understanding. The court's insistence that we are not having a trial on Michael Fosler ignored that Spencer's defense necessarily turns on what Fosler did and why Spencer reacted as he did. Fosler's conduct is integral to and critical to the assessment of Spencer's actions. Favoritism toward the state and disregard of the fair process. The court again departed from the neutrality when the prosecution belatedly produced substantial discovery and notice of an expert in his report. The defense notified the court that critical data had been produced on the Friday before the Monday filing deadline and that an updated expert report arrived that afternoon before the hearing. The expert himself admitted he planned to gather additional data and again revise his opinions. Despite the defense requests for time to review this late evidence, if not excluded, the court ordered the hearing to proceed and instructed counsel to simply listen. This refusal to grant even minimal accommodation rewarded the state's non-compliance and deprived the defense of a meaningful opportunity to prepare for their evidence and bias and administrative of the docket. Ooh, sounds like Karen Reed so bad. To ensure effective examination of the state's cell phone tower, the defense counsel requested a ruling on pending motion for pro hoc vice admittance of an attorney waiting in Arkansas licensure after leaving federal practice. The attorney was more familiar with the expert's highly technical subject matter and would have been more effective in cross-examination. The state did not object. The court stated that it already ruled on that yesterday, but in fact, it had only emailed that it would not decide the motion before the hearing. The court refused. That's what is in evidence. The court refused to rule, and the attorney did not participate in the hearing. There was no conceivable prejudice to the state, no logical reason for the court to refuse to grant a pro hoc vice status to an experienced attorney. The court has still not ruled on the motion. Oh my goodness. The continuing and unexplained delay left the defense unable to allocate trial responsibilities and prepare fully, further undermining confidence in the court's impartial administration on this case. Baseless accusations and defense counsel of malfeasance. The pretrial hearing culminated in the public's accusation of misconduct against a member of the defense team. I don't care. There are no phones during this recording and stuff going on here. She can exit the courtroom. If I see anybody else with a phone, that's what I heard. 30 minutes later, the court abruptly stopped the video exhibit and escalated further. All cell phones are out of this courtroom. There's somebody texting what's happening in this courtroom, and they're talking about jurors and everything else. And if it's not, I'll have each one of you search for a cell phone. Everybody, leave your cell phone outside the courtroom now. Somebody's texting what's happening in this courtroom, and I don't know if it's that lady I got rid of a while ago or what. It's a text. You can put it in your bag as long as it's not on. Turn it off if you want. I don't know if that lady was sending out stuff, if that was the one. I'm sure it wasn't. I'm 100% certain it wasn't. She's a lawyer at my office, and she's probably texting us information about what she's doing, legal research for us, and texting us about what she's finding. Well, she absolutely would not do that. This has to do with 4 jurors and everything else. Or anybody that came in here after lunch knew about that. When defense counsel sought clarification to the court claimed that someone had posted about the hearing on social media and implied that the dismissed attorney was responsible, the court was mistaken in asserting that only someone present after lunch would know about the voir dire procedures. They had also been discussed earlier that morning. No actual jurors were identified. Only the 4 potential jurors would have been questioned individually during voir dire. The hearing was public, and media representatives and the public did not need phones in the courtroom. Okay, we talked about the courtroom closure already. January 13th closure. The same pattern continued on January 13th, which it claims the service of the courtroom, security, decorum, and the orderly administration of justice. In reality, however, it is a functional courtroom closure that mirrors, escalates the secrecy of the Arkansas Supreme Court had stated. Technical restrictions. Cripple the defense's ability. Oh boy. All right. If you want to read this, it is on my Facebook page. If you go to my title, Legalese 123, I posted, I didn't post this one. I posted the other one. It's pretty much a summation of this one. All right. So so this goes to the judge, right? This goes to the judge to recuse herself or not. And so she's the one that gets to determine whether or not she is going to recuse herself. And my guess is good luck. I don't think she's going to do it. What can they do further from here? I don't know. I think because even in the Karen Reed case, when they asked for a recusal of Judge Cannoni, she said no, and it went through. So my guess is that this is going to go through. And what is it still going to be on track for next week? I don't know. It's a big bombshell. So stay tuned. Make sure you like and follow if you want to hear more about this crazy case. Again, I said they should have done this earlier, but now they have more reasons. So I don't know what's going to happen. So stay tuned. I will keep you posted. Thanks for watching. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.